We do, Miss. Okay, so you have Miss Adams, right? Okay. Come up, ma'am.
Is she in the jury box because she was late?
No, no,
Oh, just for late. Okay.
she's not in trouble. No one's in
Okay.
trouble. I just wanted to make sure that we had her, we don't lose her. Hi. Shall we dance? All right, so Miss Adams, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to a gas station in Harris County, Texas, in response to a welfare check. Upon arrival, the officers noticed the defendant's vehicle with a flat tire and front right bumper damage, with the defendant asleep, laying backwards in the driver's seat. The officer observed that the vehicle was off, but the keys were in the ignition. While officers were investigating, the defendant began to wake up, and the officer observed the defendant reach into her back seat. The officer opened the door and began asking the defendant how the vehicle damage occurred. The defendant stated she did not know. The officer asked for the defendant's license, and when he received it, there was vomit on it. The officer also observed vomit on the side of the door and an odor of an alcoholic beverage. Officers asked the defendant where she was coming from, and the defendant stated she left Uptown Lounge at approximately 3 a.m. and pulled into the gas station after noticing her tire was flat. The defendant admitted to having one mixed drink at the bar, and upon an inventory search of the vehicle, the officer found car keys on the back seat and more vomit in the center console. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The DIC was read and breath was consented to. The results were 0.097 and 0.095.
Okay. Did you want to say anything?
I mean, I guess the only thing that I wanted to add or just emphasize for the court that she pulled over to a public place. The car technically was off, right?
What time did the officers arrive?
And her breathalyzer was very low.
It was 8:25 hours.
So 8
a.m.
or is that 8 a.m.?
I believe it's 8 a.m. Your Honor. Yes, Your
She
Honor.
pulled into a public place because, her tire was flat. So at that time,
She
she
didn't
was,
remember how that occurred.
that's based off what the officer says, but we haven't listened to
This is piece.
Yeah, so.
The officer also did see the keys in the ignition. I just want to emphasize that, Judge.
Say that again?
He did witness like the keys being in the ignition when he approached.
But you said the keys were in the back trunk.
They
He
found,
said he saw the defendant reach behind into the back seat while he was conducting his investigation. But when he first approached the vehicle, the keys were in the ignition. I confirmed that with the officer yesterday. And it's on body cam.
If you find something later on, come back to me and we can have a hearing over it. I'm gonna find probable cause for now, Miss Adams. Don't drink, don't use any illegal drugs. I'm making that a condition of your bond. Please, ma'am, okay? Any prior DWIs? Alex?
This is her first case, Your Honor.
Okay, so you've got a great lawyer. She's relentless. Listen to her, she'll take care of you. Because you have a lawyer, I will waive your appearance. And she'll tell you if and when you have to come back to court, okay? I'm gonna have you sign a receipt with Victoria. We'll just have you get with your bond conditions with Felicia and then you're free to go, man. All right, be careful, man. Yeah, she has a license, yeah. Okay.
put your back.
Mr. Ariza, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay.
Okay.
On March 9th, 2025, in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence. The officer then made contact with the complainant at the residence, who stated the defendant had been intoxicated at a family gathering earlier, and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued in this?
It needs to be, signed.
Okay, ma'am, I'm issuing now what's called a magistrate's order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine.
Okay.
Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, ma'am?
No.
Do you work?
Yes.
Okay, you work full time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk. Do not leave until you sign our bond conditions though. Don't worry, because since you'll be monitored for no alcohol, we'll have Felicia do it. Okay, please. Deputy Miranda will give you an application.
Judge, was this one CHA?
No, I give her an application.
So the smoking jacket thing, Judge?
You did. It's okay.
Smoking.
Well, it's too early, man. Come on up, sir. Is it De Los Santos you said?
Yes. And it was under Santos
Yes, page
on the
19.
docket, but it's.
I see it. Got it. All right, Mr. De Los Santos, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 9th, 2025, at approximately 6:34 a.m., an officer responded to a major accident on the 6100th block of North Fry Road in Harris County, Texas. The officer made contact with the witness, who was traveling south on North Fry Road, and stopped at an intersection of West Little York Road, and he began to drive. When the light turned green, he was struck from behind. He exited his motor vehicle and observed the defendant in the driver's seat. The officer observed rear damage to the witness's motor vehicle. The witness stated the defendant was transported to the hospital. The officer observed heavy front damage to the defendant's motor vehicle, but no closed or open containers in his motor vehicle. The officer made contact with the defendant at Katy Memorial for Mental Hospital. The defendant stated that on March 8th, 2025 at 6 p.m. he was drinking at a friend's house. The defendant stated he drank until 4 a.m. the next morning. He admitted to driving under the influence, resulting in a major accident. The defendant had visible scrapes and injuries on his face, arms, and legs. The officer observed the strong odor of alcohol upon his breath, red bloodshot eyes, and slurred speech. SFSTs were administered. 6 out of 6 were observed on the HGN. The walk and turn and one leg stand could not be conducted due to injuries. IVs, and the defendant had IVs and the defendant was wearing a neck brace. The nurse checked his vitals and ensured the defendant was in good health to be discharged from the hospital. The defendant was read the DIC and agreed to a breath test. The results were 0.166 and 0.169.
How long from the time of the accident to the time that he goes to the hospital? Is it immediate?
So I don't believe it states what time the accident occurred and what time he was transported to EMS, or transported to the hospital, but it's before the officers were able to arrive on scene and do an investigation of the accident.
He doesn't write down what time the accident is? Do you have the OR?
Been a lot of that going on lately and DIMS.
I don't understand who's writing these reports.
I don't know, I thought intake was
No,
supposed
I
to
don't get it.
improve on January.
It's important to know how long it takes him to get to the hospital, right? And then I guess he's discharged immediately after he gets to the hospital. I mean, that can't be because he does, how long does it take to get into an emergency room? It takes forever. When I have a family member that goes to the hospital, it takes 12 hours just to get seen.
Yeah.
And then he goes and he blows a 16 after. I mean, I don't know. Look, I'll give you a little bit of time. Take a look to see.
And getting, hopefully the office report can clear it up. We don't have that back yet. Correct.
I just want to know that there's not a disconnect. Like it doesn't take 12 hours to get from here to here because you know how long it takes to get to hospitals and it's ridiculous. So yeah, I'm going to put it on hold for now because we got a whole.
Today or?
No. Later, like I'll give him a couple, like maybe an hour or so. Do you have
Okay.
anywhere else to go?
I have plenty of places to go.
Yeah, I bet. So go do what you need to do. Come back. Let's revisit PC in a little bit. Will you? Please?
Absolutely.
Okay. Take a seat. You're in the juror box. Don't leave.
Either way, it's the same day, just no matter what.
And then I think that we need to do a name change because they have it under Santos, but his name is De Los Santos. De Los Santos is the last name, not just Santos. Nathan, and it's De Los Santos.
That's correct. All three separate.
Do a name change. Right. But it starts with De Los Santos. Right. So that's, yeah. We're going to do a name change.
So we do have an office report back.
Okay. Are you ready now or do you want some time to look?
Can we have? Yeah.
Can I make a suggestion? Based upon the offense report not having any, go ahead and stand here, and the DIMS report not having the information that they're seeking, I think at this time, no probable cause finding is appropriate. However, it's my understanding that Chief Pace, since I trained him, will probably go and figure out all these facts and get it refiled correctly.
I wanted to give you a little bit of time. If,
Contact the officer.
huh?
I'm going to contact the officer.
And we already
I didn't want to
have,
go that far. I wanted to just see what the report has.
And the.
Because you being able to go contact the officer a little bit just beyond this, because it's not fair to them. But what I'm looking for is how long it takes from the accident to get to the hospital, to see, is it him that's driving? Is he intoxicated at the time of driving? Because that's what it calls for, right? That's what we need to know. So if you can just take a look real quick, go do what you need to do. Come back maybe like 45 minutes. I just want to know what the timing.
I was just going to suggest, we already have a date of 4/14, that they could get this done in the interim and not have to scramble today with 50 other arraignments. That's all I was suggesting.
And
But it's up to the court.
looking at the OR, the timeline is not.
It's not in
OR
there.
for that.
They put any time in the OR?
The times that I have is that the witness said that they had been there since 6:30, sorry, I don't know what that is about, but, the only time that I have is that the blood sample was taken at,
Breath, right.
8.
Breath, right.
He didn't write down what time the accident happened? Or what time he gets on the scene? There's gotta be something, Look at the MDTs, there's gotta be a time when,
Sorry, I'm looking at the wrong offense report, Judge, I apologize.
it's okay.
I do have based on the accident report, the crash time was 5:50 in the morning. And I'm not seeing, what we don't have your honor is, I think it's time.
I'm not concerned about that. I'm concerned what time he gets to the hospital.
Yeah.
Crash occurs at 5 something in the morning.
Okay.
Does
And
he get
he's
to the-
admitted to the emergency room at 7 a.m. So it's roughly 1 hour after.
Well, he gets admitted at 7 a.m.
Yes.
Okay, so we're about an hour and a half after the crash. What time does the officer get there? Start interviewing, do you know?
The crash is at 5:50 a.m. The officers transport the defendant in at 6, so 10 minutes later. And
They transport him to the hospital?
yes, and
Okay.
it's admitted in his emergency room.
What time does the officer get there to start the interview?
comment.
Mr. Beadle, I just want to know that everything is in close proximity because if he gets there, he starts interviewing like 12 hours later, I'm going to have a problem.
And I think the DIMS will probably be supplemented appropriately. I know how much business you have today. I see all the arraignments here sitting in the audience. I think that they will get it done by the 14th of April, which is what I already have the date for. But I leave it to the court's discretion. I'm fairly certain it's not in there. You're doing great, by the way.
Your Honor, I don't see a time, it just needs to follow right with the possibility.
And the blood draws what time?
It is at,
For the breath test, sorry.
Which is weird in and of itself, Judge, because they said he couldn't do the one leg stand or the walk and turn.
Because
But then they took him off to another location to do a breath test. It's just kind of weird.
it doesn't state that.
you don't even have the time of the breath test?
I like it, no.
So it looks like we're looking at her I would ask in that report, she would leave out to review it before considering it.
What do you think?
We have a date for the 14th. I'm sure they'll do it before then. His appearance is waived anyway, so he doesn't have to be here.
Okay, so,
Do you want to put some potential conditions on
No,
him,
I-
assuming? Okay.
so I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Any prior DWIs? And valid license?
No prior DWIs and his driver's license is valid.
Okay. As long as you have valid liability insurance and a Texas driver license, you may continue to drive. But if you don't have car insurance, do not drive. It is a condition of your bond. Don't consume alcohol. Don't use illegal drugs. Do you understand?
Yes, Your Honor.
We'll waive your appearance while you're on bond in this court, but you must stay in touch with them. If they tell me they can't get a hold of you because you're ducking and dodging or you pick up a new case, all bets off. I will put you in jail. You
Absolutely.
understand? Okay. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond condition, then you're free to go. All right. Mr. Beadle, always a pleasure. Happy Friday.
Have a great weekend.
Yeah.
And then May 14th.
What was the last name? Lechuga. Really? Lechuga.
Yeah.
All right. Good morning, Mr. Lechuga. Good morning. So you're charged with displaying a fictional license is a plate, right?
That's it.
You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant, and the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. Got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because they're not on purpose, they're accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
His driver's license is eligible.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with Casanova and Mish. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you.
There's no driving affidavit?
Just, can you file conditions, no driving without insurance?
Yeah.
We'll have you sign these conditions and then you're free to go. Okay. State's condition. You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver, advised he did not have any form of ID on his person, and provided his name as Daniel Escamilla, date of birth, April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yes, it's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Felicia, if you can send him, please.
Yes, Judge.
If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me.
Mr. Escamilla, over here, please.
Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle, and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted, and 4 bags were located under the driver's seat, 0.154 ounces.
All right, you, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man. Good luck. Good morning, Mr. Martin. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to a weapons call at 829 Custer Street in Harris County, Texas. The caller stated that there were about 10 people fighting, and the caller saw a gun. The officer observed a multitude of people walking from the street into the property and saw the defendant fitting the description as the person with the gun. The officer approached the defendant, and he admitted to having a gun on his person. Upon a frisk, the officer felt the outline of a firearm in a crossbody bag on the defendant's person. The officer removed the handgun from the bag. The defendant is 19 years old.
What's he doing wrong? All right, I'm going to find no probable cause in your case, Mr. Martin. Be careful. You know, you're 19, you have a gun. God forbid you use it. Put yourself in such a deep hole. You know, really. Go to school, get some knowledge, get a good job. You'll get a ton of money, and then life's great. Life sucks without money. I promise you. Don't end up in a hole, hang out with dogs, because all you're going to do is get fleas, you know? Take a seat, please. Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant, and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant to see if her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of Daniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she does not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had a small swelling under her left eye and was transported to the hospital due to being unconscious.
All this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU.
Oh,
I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. Do you understand?
sir, I understand. May I ask what this bar? Okay.
You have the ability to hire a lawyer, Mr. Martin.
Oh, sir.
You work.
Sir.
I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria, then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe. Otherwise, it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you. I'll go.
Right this way.
Good morning, Honor.
Good morning, sir. Let's finish this real quick.
We're gonna sign the reset, please. Your reset for your next court date. Yes, ma'am.
Okay, what was your last name again?
Mejorado, Mujorado.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers respond to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got stuck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odor of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and consented to brag. And the results were a .148 and a .143. It was identified by his Texas driver's license.
Yes, sir, I'm going to find that there's sufficient probable cause to go forward with the case. You look to see any prior DWIs, and if he has.
There's no prior DWIs and his license is.
Okay. Mr. Mejorado, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. We'll have you fill it out. I'll have you sign a receipt with Victoria. You'll get with Fleischer for your bond conditions. Then I'll take a look at it shortly. Please. Okay. Happy Friday. How are you? Good. We made it. Good morning, ma'am.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9th, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving its own lane side to side. The officer observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant to have bloodshot eyes, blurred speech, and odor of an alcoholic beverage on her breath and person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted. This is 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results were at 0.137 and a 0.132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. You also look prior to WI's license, please.
Yes, Your Honor.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
There's on the testing, what is that? If I can pass on that message.
Just random testing. No alcohol, no dope,
Okay.
illegal drugs.
I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gonna, I mean, don't come in 2 weeks though.
No.
Right. But
Okay.
yes, of course.
License is eligible, no prior to.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, then you're free to go, man.
All right, thank you very much.
Have a good day.
Don't put your stuff on the table.
Yeah.
Right here in front of the judge.
Good morning, Mr. Robinson.
Good morning, sir.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, in Harris County, Texas, at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is it?
I don't know. When the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, leave back at 11, and that's when the responded.
Can you say it again? What did he say again?
Complainant repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was therefore trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his plant field first.
He said, I'm going to get my gun and shoot you.
I don't have it both ways. Say the complainant, defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Ask a question.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard was the one who was threatening.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do, right?
If I might say real quick, I know you're busy. They have a city ordinance. That's why you can't lay at 11. But I was recently jumped. I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what,
I understand.
okay?
Speaking of the plan, where's this location? We're not in contact with this location.
What is this? What is this
It's
place?
in the hospital building downtown.
That's the Tom, that's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer, then more bad blood comes up. They file more charges. That's why.
I understand. I never said that ain't true. Already filed a motion for discovery inspection. So I need you to have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign a reset with Victoria. We'll have you take a seat. Let me find you a lawyer. and
Yes,
then-
sir.
Okay, please.
Right this way.
Good morning, Mr. Villasana.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 7th, 2025, approximately 7 p.m., officers were dispatched to a person found on the West Digital Road in Harris County, Texas. The officers spoke with a witness who reports for HFP. The witness stated that the defendant was parked when he got to the location and was asleep in his motor vehicle. The vehicle was turned on, all doors were off. The witness stated that he knocked on the window multiple times to see if the defendant would wake up, that the defendant did not respond to knocking, and that the witness had used a special tool to open the door and was not able to look at the defendant and seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the console of the car, asked the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems. And another witness stated that multiple customers had stated that the defendant had been parked at the gas station, and when that gas station made access to witness to the cameras and saw the defendant's car had been parked there since 6:30. Witness 2 went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door, but he did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. A open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it. Because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in the state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand? You get no more warnings. If I find that you do, I'm gonna lose it. Do you have the ability to hire a lawyer, sir? Okay, we will give you time to go hire a lawyer. I'm gonna have you swear to us that you're not gonna drive. I will get you to Victoria where we will have you sign a reset. You will get with Fleischer if your bond conditions. After that, you're free to go. Be careful, Mr. Villasano. Okay?
Here's something I want every one of you to think about. Today, a woman was found at her ex-husband's residence looking for her children after an argument that began at a family gathering. She had been drinking. The officer arrived to find the complainant bleeding from his face. The cause. She had struck him with a television. A television. Not a fist, not an object grabbed in a moment of panic. A television set. Picked up and used as a weapon. So here's the question. Domestic violence statutes were written with the assumption that escalation follows a pattern. Words, then a shove, then a punch. But when the first reported violent act between a couple is something this deliberate and this severe, does the legal system's graduated response model still make sense? Or does the law need a different category entirely for violence that skips every step in between? The judge issued a full protective order and ordered no alcohol whatsoever. He said, "I'm going to protect my city at all costs." Sometimes the law has to catch up to what already happened.
Más escucha el juez. Dice.
Bottom of the page. Okay. You are Alejandro Castillo.
Yes.
Mr. Castillo, you're charged with failure to stop and give information. Essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, at 9 a.m., officers were dispatched to a batch at a location in Texas. Upon arrival, the officer met the complainant. The complainant stated that she was sitting at a red light and she was struck by the defendant, and then the defendant left the scene. The complainant was able to get the vehicle's license plate. The complainant followed the defendant through a residential neighborhood where the defendant lost control of the vehicle and crashed into a house about a mile from the original crash. The complainant estimated damage to be around $2,500. It is not copyrighted.
That's what I was gonna ask you. Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you. And you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here. So you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
Ocupar su propio abogado. Usted puede ocupar su propio abogado si vamos.
No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Was that financial affidavit?
Yeah. Okay. Hey, what's up, girl? Good to see you.
Please take a seat. Did that grab? Yeah.
Good morning, Mr. Reyes.
Good morning, Your Honor.
Always a pleasure.
To see you today. Same here, sir. Look sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of West Road, Harris County, Texas, speeding, going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Officer Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to single lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. Officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have red, bloodshot eyes, thick slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. SFSTs were conducted. 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.100 and 0.101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No prior DWIs.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with Fleischer your bond conditions and you're free to go.
Thank you.
Take care. Good morning, Mr. Wolf.
Good morning, sir.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Redville Street regarding a minor crash. Officer 1 made contact with Officer 2, who on-viewed a 2 motor vehicle accident. Officer 2 observed the defendant operating a silver Ford minivan and crashed with a black Hyundai Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes and sluggish speech and poor balance. SFSTs were administered, 6 out of 6 clues on the HGN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one leg stand. The defendant was placed under arrest and read the DIC and he consented to provide a blood specimen.
It's not back.
No.
Prior DWI, one from with us or any more?
It looks like there is a pending DWI from Galveston County.
from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want.
Yes, sir. I am here on Mr. John C. Joseph. It's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
Is he here?
Yes, sir. Mr. Joseph.
It's just.
So this is basically an arraignment.
Yes, sir. I understand that we were going to do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir. We're still waiting for the security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
yesterday.
Yes.
I'm ready to set this case for trial. Way too much drama, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will
Yes,
give
sir.
you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of any weapons.
Did you say you already have something going on?
Yeah.
Is it from Harris County?
Mm-hmm. I turned myself in the other day and they ain't doing nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but
He's got 2 cases. Look at the other one, please.
yeah, neither of them were supervising an ankle monitoring order. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Joseph?
I just started looking for a job. No, sir. I just started looking for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
That's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, we'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it's not going to go well.
Yes, sir.
All right?
Happy Friday.
You mean
I'm gonna do a PSI on it rather than fully upstairs, so it's made my Friday a lot better.
scary though?
It is.
No, let me tell you, I did a PSI once where I was basically going to get probation
Yeah.
and then got smacked with 25.
And it did enhancement. I'm gone. And it's working and it's got a lot of support. And it's a really silly case. It's a silly case. It's evading arrest, but it's.
I trust you.
Yeah.
You know, you're the best, but PSI, it's just,
There's always risk there, but the state was at 15, so.
yeah.
Melgar, Daniel Melgar, this is my fault, Judge, PTI packet, he got it yesterday
Okay.
to Abigail and.
Well, not to Judge Geis, right?
Yes.
Okay.
I think
Everything's submitted?
Everything's submitted, all the discovery is turned over. It's 0.16, so it's just a little bit above the, I think he will.
Why? So were you denied?
You're told to submit a mitigation packet, yeah.
Okay, so it wasn't a denial and then you appealed,
Correct, correct.
right? They just submitted a mitigation package.
Resubmit mitigation
Got
packet.
it. All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no
so.
decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay,
If it's approved, your guys got to be here so we can send it for a T-Res.
okay,
Okay?
sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir,
Yeah.
it's good.
Okay.
Judge, thank you. Nice to meet you.
Good luck whether you were waiting on someone or,
Mr. Cough, Kevin Cough.
okay.
Go ahead and sign for me then.
Happy Friday.
Happy Friday.
With a K or the C? I see, okay.
Morning, Judge.
Sir,
Hey.
you can approach it.
I know you?
Hey, forget about it.
Forget about it.
Yes, sir. That's what they gave. If you don't have any holes, okay?
Do you guys show any holes on Mr. Kaufman? Are you on probation or parole at this time?
No.
You were on parole in 22. Is that over now?
Yeah.
Okay, so I don't show any holds on you now.
It's no holes.
I don't see any. Do you guys? You
I don't
guys?
see a hold, no.
Yeah, we don't see any holds. But if you continue with what this has happened and this keeps happening, the sentences just get longer, longer, and longer. All of it self-control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
The bottom where I can hold this trespass.
There is a trespass, right?
Here's a trespass. Was there plea paperwork for the trespass?
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. You understand? Yeah.
Yes.
Yeah. But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf. confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks a lot.
Can I start with Alator Aristelsi for bond violation? She tested positive on 3/4 on March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you second on that, Judge?
$5,001.
And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, it's the second. The first one was for the same thing.
Take your time, no rush. Deputy, you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge.
Thank you.
Yeah, 5,002.
5,000.
Yeah.
All right, Judge, and I have one more, and it's Gomez.
Okay. Jorge Gomez, come up.
So, Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand?
Yes, Your Honor.
Yes. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail.
Yes, Your Honor.
Thank you, Judge. In 50 days, Judge?
Yeah, reset 50 days must appear.
Okay, thank you, Judge.
Thank you, Judge.
Okay, that is Mr. Gregg, who has been appointed to represent you. We've given you a lawyer. It is your responsibility to stay in touch with him. He will tell you if and when you have to come back to court. You know the conditions. Don't use. I'm not asking for much. I just want my street safe. Don't use. You see what happens when you use. I have one person after the other. We're going to have to,
Sir,
we don't need another sardine. You know what I mean?
I understand.
Okay. We'll have you sign a reset. We'll get you with your paperwork, and then after that, you're free to go.
We have this information.
Yeah, the reset will have his phone number on it. You must get in contact with him. In fact,
Call me to check in, okay?
Yes,
you
sir.
get his
You get
cell
out of
phone
court.
so I
I
can
want
give
to
it to
talk
him.
to you about it.
I'm gonna
Okay,
get you a cell phone real quick. Greg, give me 1 second.
Sure.
Judge, May 13th through the 15th.
Let's see. Let's go with the 14th.
Okay.
Thank you.
Okay, thanks, Deputy Chief.
All right.
I'll give you.
All right, Judge, that's all I have. For now, again.
Is that a 6168?
6168.
All right, there it is. Okay, man. We'll have you take a seat. We'll get you with your paperwork and then you're gonna be free to go. Okay, he'll
and
call
I-
you
I
here
got the
within an hour.
number. Thank you, Judge.
All right. Come on up, please.
Yes, I can.
All right, so Mr. McGee, you've worked out an incredible, not you, your lawyer has worked out an incredible deal. You're charged with it's 5 open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle, and I think that's it, right? As part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, on the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge, years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever. So how do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem.
Yes, sir.
But would you get out there, you get on the street, you got to be careful, man. You get for one life. You don't get another one. There's no redos. Good luck, man. Yes. It's 30 days. I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
Morning.
I got appointed to Mr. Ramos. His name?
To who?
Ramos.
Okay.
Carlos Ramos.
Is he in jail?
Yes.
And this is a little bit, long-winded one, so I can walk.
You look like you were kind of iffy.
I'm playing catch up, Your Honor.
Well, so just
too.
to give you some background,
There's no rush. Take your time.
so in August of 24, he picked up a 3rd-degree PCS.
I remember now.
He had an attempted auto theft. That was a cheap case. Did it for 18 months. That was done in September. Then in March of this year, he picked up 1, 2, 3, 4 third-degree theft cases.
We were talking about this yesterday. It looks like it was one of those burglary rings where they're taking like tons of cars, and is it like a chop shop
It
type
sounds
thing?
like that sort of. I don't have all the details of the felony, but that's what it sounds like to me.
Okay.
What kind of puts us down here in a little bit of a bind is all of the allegations of the MHA are all the felony offenses.
He has no technicals?
Doesn't admit that.
Really? He was doing good on probation?
doing good on probation. He's
Wow,
completed the
until these
entire-
cases, obviously.
I can maybe get him on the co-defendants. One of the conditions was have no contact with co-defendants, but I don't know who they are.
Can you let her know? That is, I mean, that if that's a condition, that's a condition, right? One of them is, I don't know, would you mind sharing who the co-defendants are, just to see if that's something? And then, I can give you time regardless. He's at no bond on all those cases anyway, so if you want to set it maybe a week or so out. That'll give you time as well. And then you can always just amend it at any time. If it is, if it's not, and this is the only cases, obviously we can't really.
Move forward.
The problem is that that's gonna take
Right.
forever.
Yeah, and I can see defense's position of, they can't take anything because it's basically
Yeah.
accepting responsibility.
Yeah.
Unless there's some kind of technical. So I guess share that and we'll go from there. Take your, I mean, if you want to set it a week to.
Sounds good. I'll set it for a week.
Okay.
Thank you.
Okay. Come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know?
No.
No?
I believe the defendant also has a felony because he had prior thefts on it,
Really?
but she is a first-time offender. And her, yeah. And her involvement in it is not as much as the co-defendants.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as Defendant Ayala, and Defendant Sauceda entered the store and went to a cell phone station. Defendant Ayala distracted the cell phone employee while Defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, Defendant Ayala received a text message from Defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Don't talk about the.
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it.
Yes, sir.
So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay, thanks.
Here's one for every parent sending a child off to college. Today we learned about a party at Texas Southern University that ended with 4 separate women injured. One was punched and knocked unconscious for 2 full minutes. Another was pushed into a parked car hard enough to feel pain in her hand. A third had a knot on the back of her head. A fourth had swelling under her eye. All 4 were strangers to each other in the moment they were hurt. They had only been trying to help a friend who was already being assaulted. So here's the question. When someone escalates from one altercation to systematically striking 4 separate people who intervened, one after another, does the law's standard charge of simple assault, the same charge used for a single bar fight, actually capture what happened? Should the number of victims in a single continuous event change the legal classification of the crime itself? The judge barred him from ever returning to TSU and set conditions on every complaining witness. He said, "Life is too short to sit in a box that is 6 feet by 9 feet. Keep my city safe, or it is going to go sideways."
Thanks.
Judge, I have 2 bond violations. The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because I can't just leave it open. I'll leave it at 2501.
Yes, Judge. And
Okay.
then we reinstate it once it's back, if we stop.
I mean, let's see, like, more than likely, like, if it's not his fault, they just up and took him, then, you know,
Yeah, his family says he was detained by ICE and deported.
just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way. You know, like, get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it, you know? So, who's second?
And then Judge, the second one is gonna be Lambert, John.
With an L.
Yes, Judge.
Come up, Ms. Lemberg.
And Judge, I spoke with Mr. Lambert. He had a BAC of 0.03 on his interlock. I spoke with him about the incident. We talked about, you know, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday, had some to drink. He didn't drive that night, but you know, the following day he didn't know that he was going to be positive when he tried starting the car, and of course the ignition interlock picked on it. I did admonish him that, you know, your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity change.
You had a DWI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put in custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a scram monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your Honor.
Your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand?
Yes, Your Honor.
It is absolute no tolerance here for it. I don't care what your excuse is from now on. No means no. Do you understand?
Sure.
Okay?
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Judge, this is Mr. Flores for that time served plea.
You know, Mr. Flores, I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize, you know, all the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, deny naturalization under federal law, you give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
The other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty?
Good.
I'm going to find you guilty and I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you.
Yes, Your Honor.
You understand?
Yes.
All right, good luck.
Thank you, Judge.
Judge, how are you?
Soon.
It's Bob. I have Mr. Escamilla and Ms. Victoria says we need to approach you on the reset because you sent him for a drug test, Judge.
Come up, Mr. Escamilla. Positive for what?
THC, Judge.
No more.
Yes,
You
sir.
are not allowed to use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail.
Yes, sir.
No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is photo from the complainant.
Okay, if you can please
Yes.
get that.
And Judge, just for the record, I was just appointed today. Okay.
No, I'll give you time.
Thank you.
Sure. I'm gonna test you like crazy.
Yes,
Just
sir.
get ready.
I'm working.
And if you- It's on your ball.
Yes, sir. Understand.
It's your responsibility to stay in touch with her too. If she tells her she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And,
Okay, Ms. Tucci.
Yes, Judge, and we've had a long talk this morning,
Good.
and he was really good about communicating earlier.
And,
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 PM to 5 AM, so.
Judge, can it change to allow him to work?
I want proof. Show me proof. I'm not gonna take your word
All
for it.
right, but she'll send it to me, and by Monday, I'll bring it in and you'll adjust. Does he need to be here if you're gonna adjust the curfew, or can I just come show you?
I want, bring me legitimate proof and we can
And then we'll
talk.
talk.
And then, but remember, the GPS monitor tells me exactly where you go
Yes, sir.
at all times. So if you deviate,
Just working back. Yes, sir.
all right, okay.
I'll get the proof, Judge. Thank you so much.
Yes, ma'am.
All right, have a seat real quick.
I have found that there's probable cause to go forward with your DWI second in here. You also have another DWI in another county. Stop.
Okay, that was driver without
Stop.
license.
Stop.
Yes, sir.
I don't want you to say anything. I will appoint your lawyer today, but it's unacceptable that you continue to pick up cases here, there, everywhere. Unacceptable. And I don't think that a PR bond is the right thing to do. I'm now going to revoke the PR bond and he goes with you. You're a danger to our community. That's unacceptable.
Just a driver.
Stop. I will appoint your lawyer. I don't want you to say anything now. I would like to talk to a lawyer. Can you appoint him someone, please? You are not to drive at all. I don't care what you're going, what you need to do. Do not drive. The only thing I'm asking you to do is please don't kill someone on our roads. That's all I'm asking you to do, man. Every single day, we have an intox man, an assault that happens because of this.
Fantastic.
Stop. there is probable cause to go forward. We have trials to determine that, but I have found that they're sufficient to go forward. You've got multiple cases open in another county, goes with you. I will appoint your lawyer, tell your side to the lawyer, and then we can talk after. Is Tyron? John? Whatever you'd like.
So we can, maybe we
I don't know
can.
about a bond is because it's kind of.
Yeah, no,
We don't. Oh, got it.
and maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the.
I'm always happy to hear PC. Let's do it.
Yeah.
Jay, you want to do it or no?
Let's do it. Okay.
All right.
What's the contract? 255-4294.
It's on document.
Oh, it is?
Yeah.
Sorry.
Please.
Okay.
On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapon charge.
So he's at a hotel.
Yeah,
Was he, you're saying he's not allowed to be there.
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it is stated in the DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's like,
the trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. And that's why he had his bicycle. The police, I basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the hotel.
is a verbal trespass warning sufficient?
I would disagree, Your Honor, especially because this is, and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot. It excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing though.
Mhm.
You know, I mean, it could say, hey, I don't want you here. Don't come here anymore. So
But then if we, If we take that blankly, that there's a trespass affidavit, then that means.
But then
that-
anybody could say
That's
it.
correct.
Right, I get it.
wouldn't be
I
able
get
to
it.
Go in and visit my aunt, she was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down, he was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole on, I'm hoping that they'll resolve these issues. I have spoken with his parole officer, and bond or not, he is gonna have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, we'll see, right?
They are,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
The larger part of it, it's not Louisiana jail, it's not Richardson Harris jail, this is a parole violation. I think what council's saying is that for whatever they contend for the parole violation, they're gonna have it before the board. So obviously, if he takes a conviction, that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless. Something happened regardless. So perhaps he absconded or.
Because he had been here homeless off the grid, so because he had no residence and things like that. And so that's why. But for conviction here.
Right. The only problem, Ms. Sparks, is that the 14 days or any time it's told.
As long as this is going on.
Well, because he's not made, you know.
Yeah.
I think one of them should be bond.
I'm showing both their.
Yeah, no.
He's not made bond on either.
We were
of them.
told it made no sense to me.
If I may, last Friday, we revoked the bond on the local cases to keep Louisiana from coming to get him.
Oh,
that's this one?
I don't
Yes.
remember that. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay, so.
So that way you wouldn't have to go back and forth and deal with the same.
Right. You're right. You're right. She's right. Because the problem is that if they come and get him, he goes over there, then a hold gets placed on the exact same situation. So
I trust Blaze and his staff.
Guys.
Stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone.
Yes, Your Honor.
No.
Okay. Yes, Your Honor. I'll stand down. Thank you.
Mentioned that information, so we did look it up on that case. There were Olson Galveston that it was active, but we just looked it up on their public records, and that DWI, with the same cause number on the NCIC was dismissed.
But he still has open Galveston cases.
Still has open Galveston cases there for, I think it's a possession of marijuana and a driving without a license. So those are the two, the DWI is not.
Do you mind bringing him out? Mr. Wood.
He's over an 8. And Judge, I did not talk to him all about the facts of his case, and normally I do before I approach. I just wanted to reapproach on the bond, so.
Yeah.
I've already told him I'd make an appointment to talk to him.
Have you run his license?
I'll run it right now. He is not eligible.
That's too much.
I think it's happened. The clerk looked, this is driving without a license, and just assumed that was driving while intoxicated.
Yes, probably so. Need to get. You said he does have,
Yeah.
charges in Galveston? Possession?
Someone locked the back gate, and left it open for you. Now it's closed.
With license.
That's, yeah, so.
Yeah. Let me make sure they're still there.
Yes, ma'am. Yes, ma'am. I mean, I
It's
got a
okay.
job, I take probation, I got ankle monitor or something, I got a job and all that, I was thinking and I was trying.
I'm gonna help you, but let's try to get it, let's at least try to get it lower to get you out today.
I'm going to do everything in my power to protect my community.
Yes, sir.
At all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, everything in my power to protect my community.
Yes, sir.
You have 2 open cases in Galveston, and now you've picked up a case here. Does he have a license?
It's not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive, Mr. Wolf. And I want you to understand and hear me crystal clear that if I find that you drive and I don't give a rat's behind what your excuse is, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every single time you drive. I don't care that you need groceries. I don't care that a kid has to go to the hospital. I don't care that there's a burning building and you have to save 50 kittens. If you don't have a Texas driver license and liability insurance, then you're not to drive. You now stand charged with the DWI second in this court. I am now also placing an additional restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle and it doesn't have an interlock on it, because I send notice to DPS in Austin so that every police officer in this state knows you get pulled over, you don't have an interlock on that car, they will take you directly to jail. I'm going to honor your PR bond today, but I'm putting a whole host of restrictions on you. And if I find that you violate these restrictions, I will violate that bond. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, and I'm telling you, I'm going to test you within the next couple weeks to see whether you are using. If 50 plus days have passed and you test positive for marijuana, it's not going to go well for you. Do you understand?
Yes, sir.
The only thing I care are my streets and that they're safe. And if you don't have a license and you ain't got insurance, then you're not going to drive. You will now get a portable device that you're going to take everywhere you go to prove to me that you're not using alcohol. And I'm telling you now, I'm going to test you for weed here momentarily. Hey. They filed 2 surrenders on Mr. Galvan's case. I just need to know your position. I sent you a picture of it. Can you just take a look and let me know what you say? Correct. Okay, just wanted to know. Okay, thanks, Shane. All right, take care. I'm honoring our bond. I'm letting you out. You hold the keys to this jail cell. You know what's expected of you. You pick up a 4th case. I'm going to go cuckoo for Cocoa on your bond. Do you understand?
Yes, sir.
We have also given you a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you've gone AWOL, you've taken off, picked up a new case in another county or whatnot, that's it.
Give him a card before you take it back in there. Oh, okay. Thank you.
We'll have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you will sign a reset. You will then get with Fleischer for your bond conditions, and then you guys can talk about this case. Don't pick up a fourth case. Okay? All right, Ms. Teachy.
Judge, may I be excused? I've made arrangements to talk to him.
All right, good morning, Mr.
Today's
Chavez.
docket moved through dozens of lives in just a few hours. And if you watch closely, you saw the entire spectrum of what this courthouse handles on any given Friday. A woman struck her ex-husband with a television. A 19-year-old carrying a gun at a street fight walked out with no probable cause because the facts simply were not there. A man knocked 4 women down at a TSU party and was barred from campus. A woman tested positive for cocaine and went into custody within seconds. No negotiation offered. Another woman was nearly punished for taking her own prescribed medication before her lawyer caught it in time. A man on a DWI second blew a 0.3 the morning after drinking, technically violating a no alcohol order he had followed the night before. A judge revoked, then reinstated, then heavily restricted a bond for a man with 2 open DWI cases in 2 different counties, changing his mind in real time as new facts came in. A defense attorney fought a trespass charge down to a single disputed question. Was a verbal warning enough, or did the law require something in writing? And somewhere in the middle of it all, a judge paused over routine paperwork and said something was deeply disturbing, then signed it anyway and moved to the next case because the docket does not stop for unease. This building runs on momentum. Case after case, name after name, bond after bond. Most days, that momentum is the only thing standing between order and chaos. Today reminded us that underneath every name on that docket is a person whose entire future sometimes gets decided in under 5 minutes. We will see you in the
To
next
talk to him.
All right, good morning, Mr. Chavez. Mr. Chavez, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The street takeover task force was investigating a takeover in a parking lot in Harris County, Texas, when the officers observed the defendant doing donuts in the vehicle, coming within 10 to 15 feet of other vehicles that made up the pit. The officers saw the defendant do approximately 3 to 4 donuts, and undercover officers maintained visual until uniformed officers made a traffic stop. The officers observed the defendant operating the vehicle in the driver's seat.
Mr. Chavez, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver's license?
Yes, sir.
Do you have liability insurance in your name?
Not in my name.
Then you're not allowed to drive. I'm going to have you sign an affidavit with me today promising me you're not going to drive. Let me make something else perfectly and abundantly clear to you that the Texas legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from individuals who partake in this type of action. In fact, we had one here yesterday where a car was seized, a very, very expensive car on a second. Do you understand?
Yes, sir.
If I find that you endanger my public, then likewise, you will go to jail. I'm going to revoke your bond if you endanger my public. I'm going to do everything in my power to protect it. Do you understand?
Yes, sir.
Before you start driving, you must come back and get approval from us. Do you understand? Don't just start driving because I don't want to take your word that you have a car insurance. Owen can get with you, come back. He knows how to handle this. Do you understand?
Yes, sir, but the truck has insurance.
I don't, you have a lawyer. I don't want you to say anything now.
Okay.
Just get with your lawyer. He can advise you how to go forward. But I'm telling you now, I'm ordering you not to drive. You don't have car insurance.
Yes,
do you understand, Mr. Chavez?
Yes, sir.
Okay, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria. We will have you sign a reset. It is your responsibility to stay in touch with Owen. If Owen tells me that he can't get a hold of you because you're playing games, it's not going to go well for you here. Do you understand?
Yes, sir.
All right, come on. Thank you. Hey, can you file? So we need him to also sign bond conditions. Owen, I also need him to sign bond conditions, no reckless driving, donuts, racing. So we'll have him take a seat in the jury box. Once he signs it, then
Yes, Judge.
please. Felicia,
Yes, Judge.
when did we first test Mr. Smith?
So for Mr.
Mr. Smith, I see an order prior to when I was here on October 7th to have Mr. Smith, go to a drug test that day. He never reported, so that's why the BVR was filed. And so then we had the test on the 9th, and those were now confirmed by the lab positive use of THC. I believe.
So that was October 9th.
No, October 7th, we ordered them to test, they did not.
Okay.
We caught that a little late, by the BVR, and then we adjusted a little bit last week, I believe, or the beginning of.
How is it that we ordered him to test in October and he's now in December testing? How on earth? It's unacceptable.
It was a court-ordered drug test, and I don't think you wanted them to come back after testing.
But if they don't test, then they're required to come back and we either make them test again or do so, or there's other ramification, but we don't, how on earth can we go a month and a half and then nothing happens?
Yes, Judge, I understand, but we did, prior orders, we tested them again this week, and those have come back for THC.
Who was here working that day?
I can look into it, but it's really no way of knowing for sure because there was no assigned officer here at the time.
Someone had to have signed an order to go test. There's always a way. There's always a paper trail.
Yes, Judge. Sorry, this is from the court. Since they never made the appointment, but it was one of our officers' notice. So
What do we do with this, Mr. Brooker? How do we hold Mr. Smith accountable?
Judge, I know what I've done since Monday. Mr. Smith and I have talked very frequently this week. I admonished him thoroughly about the THC usage. He explained to me what happened with that, and he understands the seriousness of it. He understands what's at risk. It's correct what you said that he doesn't have any support out there, financial or otherwise. I'm actually happy that he was able to make it here on time today because I was concerned about that. So that was twice this week. He wants to be compliant. He wants to do what's best. He wants to dispose of the case.
I don't believe that.
I know, Judge.
I don't believe that. He's telling me that you want to be compliant. I don't think so. You repeatedly do whatever you want to do without regard to court orders, and it does not work like that. You repeatedly fail to appear here. You blow off the test, and now you're testing positive. What am I supposed to do? Just let you go?
I missed one day, and that was the day I was supposed to come, and I didn't have no way up here.
You can take the bus.
I'm in Humble. The bus did not come out of Humble. I'm literally sleeping at the park right now, like, okay, and I'm still, okay. Listen.
And Judge, even with those challenges, Tristan has been in school. Even on the Zoom appearance from last week, I believe he was Zooming in from school that day, the day that he couldn't make it, and got down here on that Monday.
I don't know what to believe with him. I really don't. Unless you provide me proof with something, I'm not going to believe a word that comes out of your mouth. I don't believe, because the problem is that you tell me that you're going to, you tell me you're going to do things, and then when it's time to, you don't. So how am I supposed to handle this? What am I supposed to do?
Judge, he came in on Monday. You ordered him to take the test. He went right over.
I literally walked here. I didn't have nowhere. I walked here.
He went over.
That was a whole 4 hour. I walked here from school. I walked here all the way from Chattanooga.
I'm not asking much. I don't want you to use. Do you understand?
Judge, if I may add, I have communicated with his grandmother. I believe it was on December 5th that I called
Oh,
her.
you spoke with Grandma?
I did.
Have you let Mr. Brooker know first?
Yes, Judge, I recorded. I took details of the conversation and shared it promptly with Mr. Brooker.
How do we go forward?
So it appears as though, based on my conversation with Miss Karen, that the defendant has gone to the house, the residence since then with his friends. He refused to leave even upon her request. There is a MOAB in place, Judge, where he was supposed to have no contact with the residents, and per his bond conditions, I don't believe he was supposed to have contact with her either. And he has gone to the residence.
And now we have even more. I mean,
And she did file a police report, I believe, Judge. She told me she called the police and they filed a report and she has an offense number.
Mr. Brooker, do you guys want to talk about this and then?
We can, Judge. We can.
Does she want him to come back or no?
No, my understanding, and I also heard from one of the family members, I believe Tristan's sister, they don't want him to come back. And mentioned something about whatever was the underlying dispute about some property or whatever. I didn't respond to it at all. Just didn't seem like the right thing to do. But as Tristan has indicated, everything he said to me is that he's been living outside, doesn't have anywhere to go, which is my original concern with him. Took him downstairs to try to get him some kind of services. It's just not really a workable situation, but he's communicated with me. We've talked this week. This is his second time here. He took the test, Judge. He was forthright with me. He understands what can happen. I told him, nobody's going to bond you out.
What do you want me to do?
Judge, just that he continue having no contact with any of the complainants. They are fearful of the defendant. They do want him to get help. I've also spoken to his mother and she wants him to receive mental health treatment. He does have
Do you need a place
propensities
to
towards
stay?
violence.
I have like some nights.
No, you were telling me earlier that you're living on the street.
I am.
Do you have a place to stay? Okay.
They told me
If you want, we have places for you to go. I have services for you. I have Shatoria here. We can find you a place to stay if you need it, because the street, it's not a good place to live. The streets will ravage you in ways that you never know. You'll do things just to survive. It's not a good place to be. So if you need a place, we can find you a place. But that's still no excuse to violate conditions of bond. We've ordered you not to go back to this house, right? I get that you may have, issues, where to live, where to stay, who to be with, how to get there. But if they don't want you there, then you can't go. And I mean, they've already called the cops.
I spoke to his family, Judge. They were under the impression that the defendant was living with a friend in their house, so I don't know.
And that's my understanding too, and Tristan did tell me that he intended to go and stay with a friend. But that was 2 months ago, Judge. He's not paying any rent or anything. His situation has changed since then.
Look, I'm trying really hard not to put you into custody, but at some point, your actions become your own and it's on you. I'm not going to keep playing this game. I'm not, I expect you, like everybody else, to live to the conditions. When we tell you not to go back, it's mom or grandma.
I spoke to both, Judge. Grandma wants no contact.
If I hear it happens again, get ready. You're not allowed to use. And I'm telling you now, I'm going to test you for someone dropped the ball here. And I'm going to give you the benefit of the doubt, but I'm telling you, you're going to get tested again. And if it tests positive again, there's no excuse. Now, we have resources to help you. If you want help, all you have to do is ask. We've given you a list of places that you can call, that you can go stay. They will take you in. If you need any other resources, we're happy to help you as well. But at some point, there's just no more excuse. Understand? All right.
Good, Judge.
Hey, that's it. I mean, really, just no more tolerance. I mean, I don't know, this is what, 3, 4, how many times is this?
It's our second time back since the first time, but I do understand. I agree. Yes, sir. Yes, sir.
All right.
Thank you, Judge.
right, Sala. So I guess let mom and grandma know, hey, there's we've tightened the leash. There's no more excuses. Any more issues, let us know. And
Yes, Judge. And to be fair, it was, the mother did tell me that she has not seen him. It was the grandmother. And
okay, well, that's good news. All right.
Judge, and I.
Okay. Who do we have here?
Mr. McCray, Your Honor.
All right. Good morning, Mr. McCray. Mr. McCray, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On April 3rd, 2024, the officer was dispatched to an apartment in Harris County, Texas, in response to an assault call. The complainant is the defendant's daughter. The complainant is the defendant's daughter's boyfriend, and the complainant was staying with her daughter, and when she got on the phone call from her boyfriend. The defendant got upset and said he was tired of this bitch's voice, referring to the complainant. The defendant got in the complainant's face and punched her in the lip, causing pain and for her tooth to fall out. The complainant was treated by EMS.
Mr. McCray, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. Do you understand? In fact, I'm going to send you right now for a drug test. I want to know what, if anything, is in your system. I'm also ordering you not to be in possession of weapons and not to have contact with the complaining witness in this case. Do you understand?
So they want to write an affidavit. Can they do that?
I don't answer questions, Mr. McCray. I'm telling you what the expectation of is while you are in this court. You can either abide by the expectation or the other thing is going to happen. Do you understand? Are you high right now?
No.
Be careful. I'm sending you for a drug test. If you fail to go take the drug test, if you fail to come back, you know what's going to happen. Just take a seat for me and then we'll get you. I'm sending you for a drug and alcohol test right now. Do you understand? Take a seat for me, sir. Top of page 11. Sorry, I want to know how come up, Miss Imam.
You just met, so we
Okay.
haven't had a chance to.
I'll give you a little bit of time, but
My understanding is procedurally what has happened is she was on a pretrial diversion.
Correct.
Her previous lawyer has passed away.
Mhm.
The state has rescinded or terminated the pretrial diversion that she was on. I've had a chance to kind of go through a little bit in the way of discovery. She wants to move forward and try to figure out what we're doing with the case, needs me to do that. By way of background, she works as a pharmacy technician at Walgreens, as a student in college. Quite a bit of mitigating stuff. I need to really have some time to dissect it all.
is she using while she's on bond? Was that the issue?
Let me see, Judge. I'm not sure why Nathan.
Shatoria, tell me about Miss Imam, huh?
It looks like she had continuous violation on her device after being placed on a zero tolerance. She had a pattern of failing to report the visits. She failed to complete SOP. She failed to maintain the alcohol monitoring device. I don't see any. The violations on the device were skip tests.
And Judge, I think there was some times where there were some missed tests. I don't know that.
So I'll give you time.
Yes, Judge.
Okay. I'm putting a scram on your ankle now, so I know that you're not consuming alcohol. And if I find that you consume alcohol, or if I find that you're consuming illegal drugs, it's really, really not going to go well for you.
Yes, sir.
Do you understand?
Yes, sir.
Yes.
Does she have a Texas driver license? Just.
You run it, Judge.
Yes, she
It
does.
hasn't been run. Okay. You're running it? Okay.
So let's do this. I'd like her to get a scram today. I'm also going to send her for a drug test because I want to know what, if anything, is in her system. We'll sit you off 2 weeks for you guys to decide what you guys want to do. Okay? Get what you need. Your case is 530 days old. It's time to decide what we're going to do. It looks like they've already kicked you out of the program. I don't know if they're going to relent and let you back in. I don't know. But I'm going to tell you now, let's just cross that bridge when we get there, but
What I would like is if in maybe 60 days or something like that, if things are going well on the scram device, maybe come back in and revisit and get a.
I don't, well, no. I don't know if I'm going to keep the case open 60 days. It's 525
Fair
days, you know? I mean, I'll give you some time,
I just
but
need to make sure all the
We
discoveries.
do have an offer in on this case as well.
what is
We
it?
put an offer, a time served.
Okay, so there's an offer. So when we come back, you know, I'll give you 2 to 3 weeks, but when we come back, you need to either accept the plea bargain from the state or I'm going to set your case for trial. If I find that you're using or doing anything to violate the law while you're on bond, now I'm going to put you in jail. Do you understand?
Yes.
That's it. You're not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, do not drive. Do you understand? Okay. So we'll give you 3 weeks, Mr. Garris. But at that time, when you come back, either accept or if you're going to provide mitigating evidence to the state,
Try to get back in the post.
before that day, so we know.
I will do that in advance.
Please.
Yes.
Okay, Ms. Simon. All right, so I'm going to put the devices on her today. She gets a test today and all fees waived.
Thank you.
Judge, my apologies, I misunderstood. Could you please go over those conditions again for me?
I want to send her for a drug test now,
Yes, Judge.
and I'd like to put a scram on her ankle now today as well.
Yes, Judge.
Okay? We'll set the case. I'm sorry?
Did you want random UAs as well?
Well, no, I just want to know if she's clean now or not. And then in 3 weeks, this case is one way or the other.
Yes.
And then, okay?
Thank you, Judge.
All right, guys. Working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State. And in that case, it overturned even Lemming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide.
a danger to another vehicle. There's other vehicles around. And this is on TC Jester Boulevard, a very sparse road at night. And this
So what were the indicative facts?
I'm opening the offense.
Yes, Your Honor, we're looking at the offense report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Well, right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30 minutes, it's fine.
My offense report's not running for some reason, so.
If we may have a little bit more time.
Mr. Simon, do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
that's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
No problem.
Just take a seat from me, Mr. Anderson. We'll come back. For now, we'll have you sign a reset.
Oh, no.
Okay. Hi, Counsel.
I've got Moises Serious.
What's the last name?
Moises.
What was the last? SI? Okay.
Assume you know the one I'm talking about.
Say it again?
Somebody walking, black man walking.
Oh. Good morning, Mr. Sirius. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's vehicle at 1:05 a.m. after observing it drive at a westbound on Washington Avenue, following a vehicle in front of him too closely, and for having an expired registration. The defendant was the sole occupant of the vehicle and driver, and upon contact with the defendant, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, and low and mumbling speech. The defendant admitted to drinking, and standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn 3 out of 8, and one leg stand was 1 out of 4. The DIC was read, but the defendant refused, and a blood warrant was signed and executed.
Okay. Mr. Sirius, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
I do, yes.
Okay. Do you have valid liability insurance in your name?
No, it's not my vehicle.
Okay. If you don't have car insurance, then you're not allowed to drive. I'm making that a condition of your bond. If you want to drive to follow the Texas law, you must have a Texas driver license or a driver's license from another state, and you must have liability insurance in your name. If you don't have both, then no driving. I am ordering you also as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, likewise, your bond will be revoked. You'll go to jail. Do you understand?
John.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Stone, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you, you're playing games, I'm going to issue a warrant for your arrest.
John.
I'll have you go to Victoria, sign a reset. We'll have you get with your bond conditions with Felicia, and then you guys are free to go. All right, guys, thanks. Thank you. It's fine. Yep.
Wait a second. Next judge is page 2. Chavez, come on up.
Okay. Did you have a?
Yeah, arraignments, Mr. Chavez.
Okay.
You're good.
Good morning, Owen.
Every other weekend we go to, there's a small restaurant called Prima Pasta. They have a singer who wears a different blazer every time he comes in. How many
Does this look like
it? How many blazers do you have? I guess.
Quite a bit. Good morning, Ms. Chestnut. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On December 5th, 2024, the officer responded to a flock hit for a stolen license plate, and upon locating the motor vehicle, the officer conducted a traffic stop. Upon contact with the defendant, the driver of the vehicle, the officer detected an odor of an alcoholic beverage, slurred speech, and red glossy eyes. The officer confirmed the VIN was a match with the stolen vehicle hit on MDT, and the defendant admitted to drinking 2 drinks, one of which was a large margarita. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 0 out of 4. And the reason for one leg stand being so low is because the defendant walked instead of doing the one leg stand. The DIC was read but refused. Blood search warrant was drawn and executed.
All I see is just the DWI. That's it.
Yes, Your Honor, there was no charges filed, and I don't know the reason for that. We can look more into that, but
It's not, okay, so, any prior DWIs?
no, Your Honor.
Did you run or NCIC?
Yes, Your Honor.
Ms. Chestnut, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, ma'am?
Yes, sir.
Have you run a license?
It's eligible, Your Honor.
I'm ordering you now as a condition of your bond not to drive any vehicle unless you have liability insurance as well.
I have
It's part of your bond conditions. I am also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If we find that you're consuming alcohol or any kind of illegal drugs, I'm going to revoke your bond and put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Okay. What do you do for a living, Ms. Chestnut?
Social Security.
Okay. Did you want to apply for an appointed lawyer, ma'am?
Yes, sir.
Okay. Do you mind? You know what? Let me see if I have one on file. Hold on. I need you to fill out an application for me. I'll take a look at it to see whether you qualify or not. If you do, then we'll appoint your lawyer. So for now, I'm going to have you go to Victoria, sign a reset. He's going to give you the application and then we'll have you take your seat in the jury box, ma'am. Okay? Please.
Craddock, Khalil, page 3.
Good morning, Mr. Craddock. Mr. Craddock, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Judge. One moment, it's loading right now. Okay. An officer was dispatched to a target in response to a theft. The officer made contact with the complainant, the loss prevention officer, who stated he observed the defendant come into the store and make a small purchase, leave, and then return and conceal merchandise in the shopping bags. The defendant then took the concealed merchandise and walked past all points of sale without paying. The total taken was $750.05.
And was he with anyone?
No, Your Honor.
All right, Mr. Craddock, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
I am currently waiting for a call to back so I can working.
Say that again.
I'm waiting for our college to get back to me, but I'm currently working at Taco Bell.
So you graduated from high school? Yes. Okay. Did you want to apply for an appointed lawyer, sir?
Would it be okay if I ask my mom that?
Is your mom here? Sure, of course. Mom, come on up. Thank you so much for coming. Did you hear what happened? Okay. I'm asking him if he wanted to apply for an appointed lawyer. I don't want to talk about the case. I only would like to know, do you want a court-appointed lawyer?
This is his first. He's never been in trouble.
Let's not talk about the case.
Oh, come on.
I only want to know whether you guys would like a lawyer or not. Let me put it to you this way. You need a lawyer.
I was about to say yes, sir.
So you can either go hire a lawyer. Right. Mr. Craddock, theft cases are probably one of the worst possible cases that you can pick up in this life. Once you are branded a thief, it's going to be nearly impossible to get a job. I have people that come back to me and say, hey, man, I can't get this apartment because I got this theft conviction. Please. It's truly one of the worst. You're just now starting in life. Life is hard enough for a young black man in this society. Now you're going to make it even harder. Come on, man. Really? Go to school, study hard. You become something in this life. We'll give you a lawyer now. Don't go back to any target. It's a part of your bond condition. If I find that you go back to target, guess what happens? Right. I'm not asking much. Just follow the law. Don't pick up any new cases. Don't go back to target. And then I'll provide you a lawyer today. All right? Okay, guys. I'm going to have you sign a reset with Victoria. We'll have you take your seat in the jury box. I need you to fill out an application for me, and then we'll have you talk to someone. Okay? Yes, ma'am.
Judge, page 6. Gaspon Gerardo.
So, no going to target, please.
Yes, Judge.
Who you say?
Top of page 6.
Gascon. Good morning, Mr. Gascon. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 6, 2024, officers conducted a traffic stop on the defendant's vehicle after observing it travel at a high rate of speed, approximately 67 miles per hour in a 50-mile-per-hour zone, and turning without using a turn signal. Upon contact with the defendant, the officer observed a strong odor of an alcoholic beverage and red glassy eyes. The defendant advised he was coming from a company party and admitted to drinking 2 beers. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 0 out of 4. The DIC was red and the defendant consented to breath. The results were 0.166 and 0.167.
Okay. Mr. Gascon, I'm going to find that there's probable cause to go forward with the case. Did you run his license?
Eligible, Your Honor.
Okay. You are not allowed to drive unless you have valid liability insurance, and I am making that a condition of your bond. Do you understand?
Sure.
I am also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, it's not going to go well for you. Do you understand?
Sure.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. You'll get with Felicia for your bond conditions, and after that, you're free to go.
Yeah.
Don't wait. You need to get on it quick. There's a lot of timing requirements. All right? Okay, please.
Next judge is page 7, Gonzalez, come on up.
Mr. Capitan, come on up. How are you? Great to see you.
Good to see you, Judge.
It's me.
You look very sharp.
Morning, Mr. Gonzalez.
Morning, yes, sir.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 7th, 2024, officers conducted a traffic stop on the defendant's vehicle at approximately 1:59 a.m. after observing it driving without lights when required near the Texas Avenue. And the officer observed the defendant to be the driver and sole occupant of the vehicle. Officers observed the defendant to have red bloodshot, watery eyes and appear unsteady on his feet. The officers also observed a strong odor of an alcoholic beverage emanating from his breath. The defendant stated he was coming from a bar where he had been drinking since around 11 p.m. The defendant had 6 clues on the HGN, but refused other standard field sobriety tests. The DIC was read, but the defendant refused. A blood search warrant was drawn and executed.
Got it. All right, Mr. Gonzalez, I'm going to find that there's probable cause to go forward with the case. Have you run his license?
Yes, Judge, it's eligible.
Mr. Gonzalez, I'm ordering you not to drive unless you have valid liability insurance in your name. Do you understand? I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're going to be randomly tested. If you're found to be consuming alcohol or illegal drugs, you will go to jail. I don't know if you'll get another PR bond. Do you understand? Now you have a lawyer. You've got a great lawyer. Listen to him and he'll take care of you. If he tells me he can't get a hold of you because you're playing games, then I will issue a warrant for your arrest. I'm waiving your appearance so you don't have to waste your time coming to court, but you got to stay in touch. You understand? All right. I'll have you go to Victoria, sign a reset. We'll get you with Felicia for your bond conditions. Then you guys are free to go.
Thank you, Judge.
Any questions?
Your driver, we'll talk about that. I drive every day, and said, insurance on my name.
Insurance.
You guys talk. If there's anything else that you need, you can always come back. Yeah. I'm so happy that you're here. I'm really, really happy that you're here. Thank you for coming.
No problem, no problem.
Really, you know, I think that it's a big feat that you're even here because in times past, yeah. So I'm really happy that you're here. Come back. Good things happen, Ms. Mireles, when you come back. We're not, you know, we're not bad people, I swear. You know, so what's going on now?
He picked up this evading. They're waiting for discovery on it before they make an offer. They want to look at discovery before they make an offer.
Is discovery complete?
We're still waiting on body cam and dash, Your Honor.
Okay, I mean, it's only 50 days old. Where are you living? What are you doing with yourself these days?
Shh. I'm still staying with kind of in between shelter, and then I'm also on the street a little bit. But
no, how do we get you off the street?
Hard. I went to the McCart houses, and I went there, and it was very strange because with the paperwork and everything that I had to deal with, it was hard to explain. They told me I was going to one house, but I ended up going to another house, which was complete opposite of what they had said that I would be going to. The conditions were much worse than I had expected, and it just
Shatoria, what can we do to help Mr. Mireles as far as housing? Do we have? He's going to qualify for the TAP funding. I mean, there's no doubt. We've got a list of places. Do you have a phone?
Yeah, I run off Wi-Fi, but I do have one, so I call.
Do you have a phone? Okay, so there's a list of places that you can go there that, so what specifically can we do, Shatoria? Like housing wise?
I think
Oh, well, no, but I mean, I know that you have stuff to do. I mean,
He can follow me back to the office and we have a social worker there.
wonderful. Do you mind doing that so we can find you a place to stay?
Yeah. If not today, I have to get her to the vet and it's offered for free. She has to get her shots.
Whoa. I don't want, if once you go, you're not coming back. You're here already. Just why don't you go talk to them?
If I miss her shots, but I'll go.
You get the shots later.
Yeah,
Okay? Whether you get it now, whether you get it in 4 hours, it's not gonna make a difference. You're already here.
I understand, yeah.
Really, we can try to find you a place to stay.
Okay.
Or would you prefer to stay on the street?
No, it's just, I don't know, I'm not so optimistic. I've tried several times and
It's a lot with the initiative that the city of Houston is doing, getting the people off the street, shelters are filling up.
I just kind of gave up hope with getting help.
Don't give up hope. Never give up hope. There's always something out there. We can always find you something. It's you gotta want it though.
Yeah,
right?
I do really want to.
And stay with Lori. Let me get you over there today. I mean, I'm happy that you're here. No one's gonna do anything to your bond. Just keep coming back and good things will happen. The only other thing I'm gonna ask you to do is stay in touch with Lori. Okay? Whether it's via email, whether it's phone, however it may be.
Yeah.
You know, when you do that, good things will happen. Unfortunately, we can't do anything with your case today because they don't have any evidence. Can you get it as quick as possible, Alex,
Yes,
please?
Your Honor, we can reach out and get an escalation, Your Honor.
Please.
Yes, Your
You
Honor.
know, time is of the essence.
Yes, Judge.
So why don't we pick a court date now so he knows when our next setting is? Okay. Please go with them, all right?
Okay, well, yeah.
Come on. Good things happen when you come with me, you know that.
Really? Thank you. All right. Hey, it's great to see you, Mr. Menendez.
you.
Really, I'm proud of you for coming. I want you to understand that above all else, here, I'm going to protect my city at all costs from every single person. I don't care who you are. I don't care what color you are. I don't care if it's a small farm animal. I will do everything in my power to protect this public at all costs. And if that means making your bond extremely high, I'm going to do it in a heartbeat. There are certain expectations that we have here. You are not to use alcohol. You are not to use illegal drugs. I'm going to test you again 45 days from today. And if you test positive for marijuana, that tells me that you've continued to smoke. If you stop today, then the next time you come back to test, you should test negative. Do you understand? It's gonna stop one way or the other. You're not to have contact with the complaining witnesses in this case. You're not to be in possession of any weapons, and you're not to pick up a new case. You know what the expectations are. So if you violate these conditions, you know what's gonna happen. Do you understand? We're gonna reset your case to give you time to hire a lawyer. I'm gonna have you go to Victoria, sign a reset. After that, we'll give you 45 days. We'll see you back then. Expect a test. It's going to happen.
And
Do you
said
understand?
my lawyer, name right here. That's don't know who my lawyer is.
I don't think did we give him a lawyer? No, and it's late. So what I can do is if you want to come back next week, we can give you a lawyer. I'll give you an application to take home, but it's late now. Everybody's gone. Pick a day next week. You want to come back and we can give you a lawyer that day. But understand, in 45 days, I'm going to test you. Don't do anything that necessitates you having a gun. Don't have a weapon. Do you understand? All right, come on.
I can text her now.
Yeah, please. All right. You are Roland Gomez.
Yes, sir.
Mr. Gomez, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 7th, 2024, officers were dispatched to a disturbance regarding an unknown weapon at an apartment complex in Harris County, Texas. Upon arrival, the officers met with the complainant, who advised that the defendant, her brother, came home from work drunk and began arguing with her. The complainant stated that at one point, the defendant told her, "I'm going to fuck you all up, I'm going to beat your ass, and I don't care who gets in my way." The complainant stated she was in fear for her life and believed the defendant was going to follow through with the threat to her. Upon making contact with the defendant, the officer observed red glassy eyes and a moderate odor of an alcoholic beverage.
Got it. All right, Mr. Gomez, I'm going to find that there's probable cause to go forward with your case. You have the rip done. What does sister want? Does she want to continue to have contact with him?
Your Honor, the rip has not been completed at this time. Do you mind? The rip is not done on this one for no contact. Go.
You don't have a number, Judge, on that one. And that's the one we already.
Right, I was making sure.
I looked at the offense report, Judge. There's no number listed on it, and there's no number listed in the CCH. So I just am gonna get my investigator on it. I couldn't locate her, and that's why I couldn't do the rip.
So, Mr. Gomez, the way it works is that I'm going to order you not to have contact with this person because I don't know if she wants to have contact with you. Until I know, I'm going to order you not to have contact. I'm also going to enter in a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. You pick up one of those, things will go sideways extremely quick. I am also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, likewise, you will end up getting your bond revoked. Do you understand? What do you do for a living?
One more, sir. Car pusher.
Good.
And I'm just
A month. I don't want to talk about the case.
No.
You need a lawyer to represent you, and I'm asking you these questions to see whether you have the ability to hire a lawyer.
Oh, I don't have I don't have the money to hire, but I thought I signed for.
I'm happy that you're working. It makes me happy, and I'm happy to give you a lawyer. If you're working full-time, even, I don't care. You're not killing it, that's okay, but I'm happy to give you a lawyer. My only concern is follow the law. Don't be a danger to my public. Do you understand?
Yes, sir.
As long as you're not a danger, you and I will be best friends. Otherwise, we'll be mortal enemies, and I'm telling you, it's not going to go well. Do you understand?
Yes, sir.
Just keep working, do your thing. I already have an application on file. So for now, I'm going to have you go to Victoria, sign a reset. We're going to have you take a seat in the jury box while we compile all the documents, while we sign it, and then I'll have you talk to a lawyer here momentarily.
Okay. And my only question is, they wanted to see like paperwork. To see at my job, they wanted to see some paperwork that it could show that I can't go back to work. Since the moment I had gotten the PR bond, they just asked me to wait to go to court. It's temporarily just see.
Do you need like a work excuse?
No, to like, am I allowed to like go bad? Like they told me to take.
So let's do this. Let me give you the lawyer. You can talk to the lawyer, and the lawyer can talk to me, and we'll go forward. Okay? Let's just do that.
To work, yes, sir.
Yeah, and I want you to go back to work. You need to be productive, right? So, all right, let me have you just sign a reset, and we'll have you take a seat in the jury box, and I'll find your lawyer here momentarily. Okay? All right, bud.
All right, Judge, next is page 7. Come on up.
And Your Honor, on Gomez, no contact, no weapons for bond conditions.
Don't worry about it, because we're monitoring him for no alcohol.
Yes, Judge.
Right?
Judge, you said no firearms or weapons?
Yeah. No alcohol, no drugs, random UAs, no contact, no going back to the house in question. I think that's it. Ms. Okafor, I have your client in the box. So if you want to do PC, you have an arraignment, right?
Yes.
So let me just do this and we can get you, okay? What's her name?
Guidry on
Got
page
it.
7.
All right, good morning, Ms. Guidry. Ms. Guidry, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On December 7th, 2024, at approximately 2:35 a.m., the officer conducted a traffic stop on the defendant's vehicle. After observing it stopped at a light with the right turn indicator on, but the vehicle not moving. The light cycled 2 more times to green, but the vehicle did not move. Upon making contact with the vehicle, the officer observed the defendant, the driver, and a passenger to both be asleep, and the passenger had an open liquor container on her lap. The vehicle was in drive, and the defendant's foot was on the brake pedal. The defendant eventually woke up after continuous attempts to wake the defendant and the passenger. The officer observed a strong odor of an alcoholic beverage on the defendant's breath and person. The defendant admitted to drinking 3 Hurricanes and 2 Amarettos, and standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 7 out of 8, one leg stand 4 out of 4. The GIC was read and the defendant consented to breath. The results were .107 and .103.
Got it. Ms. Guidry, I'm going to find that there's probable cause to go forward with the case. Does she have a Texas driver license?
It's eligible, Your Honor.
Okay. You're not allowed to drive unless you have liability insurance in your name. This is a condition of your bond. If you violate these conditions, then you will go to jail. Do you understand?
Yes.
I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. Likewise, you test positive for drugs or alcohol, illegal drugs or alcohol. It's not going to go well. Do you understand, ma'am?
Yes.
Tell me, what do you do for a living?
I am a CPA.
You're a CPA. How much money do you make a month?
How much money I make a month? I want to say like 8. I'm not.
8,000?
Yeah, I'm not.
Amazing.
It's amazing.
Are you 8,000 a month? Are you kidding me? That's amazing. What are you talking about?
But this is embarrassing.
Killing it. No, it's all right. Let's not say it again any further. You need a lawyer to represent you, okay? We're going to reset your case to give you time to hire a lawyer. So what I'm going to have you do is I'm going to have you go to Victoria, sign a reset. We'll get you with Fleischer for your bond conditions. You really make that kind of money, Mom? Doing that?
Exactly. I'm aiming to.
Oh.
Something, but almost.
You work full-time?
No.
Can you afford a lawyer?
I can.
Okay. We'll give you time. If you ever have any issues, come back, talk to us, and then we can always go further, whether you need an appointed lawyer or not. Okay? So I'm just, communication is key. I need you to talk to me, and then we can, if you need, we can appoint your lawyer if you have any problems out there. Okay? All right. So understand this, though. There's a lot of timing requirements with the DWI. So don't wait. Get on it quick. Okay? Yes, ma'am.
Page 8, Jimenez, come on up. Page 8, Jimenez.
Is that you?
It's my dad. It's my dad, sir.
Where is Vladimir Jimenez?
Now the detention center, sir. I did.
So
I did hire a lawyer, sir. She's supposed to be in contact with you. Miss Esther.
Esther what?
I don't know, I just have.
You have a,
Apparently the dad is the one that's on the docket and this is the daughter trying to say he's in a detention center somewhere.
right, so
But it's, yeah.
just, let's do this. I'm going to readdress this in a little bit. Let's see if is your lawyer supposed to come here today?
No, she can't. We've been talking all week and she said that this was too on top of her schedule, so she
Okay, so let's do this. I'm going to have you take a seat. We'll come back in a little bit and we'll figure out how to go forward. Do you know how to look at the,
I can see if they're.
if not, I'll do it in a bit. Once we do, we'll look to see if we can find him online, if he's in, ICE. Ms. Okafor, are you ready? Hey, all right. Good morning, Ms. Torres.
Good morning, Your Honor.
And you are wanted out of the state of Colorado for assault 3. Are you waiting formal extradition, ma'am?
Yes, sir.
Okay, this is for the 14 days. You understand, right?
Yes, Your Honor.
So she has a local hold. She's charged with endangering a child here. And so it's set out in March. We'll pick a time in January when Abel already has another setting to just check.
She has not made bond on that case?
That bond's currently at 50,000 as well.
Okay, so
I was trying to see when Abel has.
So you're familiar with the process. I'm sure you explained that the typical requirement for that other state to come get you is basically told while you have not made bond on that case. Once bond is made, at that point, that's when the time starts ticking for Colorado to come get you. Okay?
Your Honor.
So I guess we'll just, and I think she has other out of county holds too, right?
I want to make sure I have it right. I think I saw another hold, but
I see out of La Plata. Oh, no, wait, that's Colorado.
she has an out of county potential engaging organized criminal activity. She also has an immigration hold. So obviously those other two, I don't know what the other, I don't know what the other county is, but that hold was placed at the same time this fugitive case was filed.
Okay. All right. Well, regardless, man, we wish you the best of luck. Okay? Thank you.
January 6th.
You are Victor Jose Garcia Bejarno. Sir, you are charged with tampering with a government record. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On December 7th, 2024, the officer observed the defendant's vehicle with a defective front headlight and a temporary tag with an expiration date of September 2024. The officer found the tag was registered to a white BMW and not the Chevy Impala the defendant was driving, and a traffic stop was initiated. The defendant told the officer he bought the car from a friend over 1 month prior, but did not receive a bill of sale. The officer found the tag was fictitious after running it through MDT.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. I don't know what your immigration status is, but I'm going to give you a warning now. And this is the only warning that you're going to get. If you are not in this country with permission and you go to jail and immigration finds you, they will very likely put an immigration detainer on you and you will be stuck like Chuck in custody until the case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. If you do not want that to happen, do not violate our laws. You are not to drive if you don't have a Texas driver license, and I'm making that a condition of your bond. Do you understand? Have you seen whether he has a license or not?
We have no license on file, Your Honor.
You're not allowed to drive. Do you understand? Yes or no? You will be signing a promise with me today, Mr. Garcia, that you understand and that you're going to comply with this if I find that you drive, because you're to have a Texas driver license and liability insurance in your name. And if you don't, there'll be a lot to pay. How old are you, sir?
27.
What do you do for a living?
We're putting them on.
How much money do you make a month?
Dinero and It depends on how many lawns I get to cut. It's sometimes about 200 a week.
Okay. Did you want to apply for a court-appointed lawyer, sir?
Era por un abogado de oficio.
Sí, pero no tengo nada.
Yes, but I don't have any money.
Don't worry about that.
Acerca de eso.
I'm going to,
Voy a-
if you qualify, I will provide you a lawyer today. I want you to understand that I take these laws extremely serious. And when I'm telling you not to drive, do not drive. Do you understand? I don't want you to say, but I want you to understand. All right. We'll get you to fill out all the paperwork and then we'll get with you here shortly.
More Spanish speaking one way. Step all the way up for you. This is Mr. Caceres, Your Honor, for the waiver. Turned out we didn't need a translator after all.
Right. Good morning, Mr. Caceres. So Amy, what's he wanted for?
He's wanted for first degree sexual assault. He's right now.
Okay. So are you waiving formal extradition, Mr. Caceres?
Yes.
Okay. We got you. We'll just need you to sign the document. And then that's it.
Thank you, Judge.
Thank you, Judge.
All right. So did you get the particular county?
Yes, we figured it out. It's,
Thank you, John.
Okay, take care.
we figured it out. Thank you.
Okay, thank you so much, Ricardo. I need to sign it.
Yeah, it turns out we don't need to count. Yeah.
Can you imagine if we did? That would be like literally
An argument, it's like,
open. No, make the argument. Really, it doesn't hurt.
I was in disbelief, you don't need to count, really?
Okay, Mr. Saman. Oh, hold on.
We just had, one more Spanish speaking agreement, that was Martinez on 10. Just waiting for Victoria.
For the next one. Martinez, come on up.
Juan Manuel. Come on up. Hey, keep it down. Juan Manuel Martinez.
Yes, sir.
So you're charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are married. On December 5th, 2024, officers were dispatched to a residence in Harris County, Texas, in reference to a family disturbance. Officer met with the complainant, who stated the defendant arrived home intoxicated. The defendant was still in his car, and she went over to remove the keys from the ignition. The defendant walked up to the complainant, landed on her left knee, on herself with her left hand. The complainant stated she felt pain from being pushed and from hitting the ground.
Mr. Martinez, I'm going to find that there is probable cause to go forward with your case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I don't know what your immigration status is, but I'm going to give you a warning now. And this is the only warning that you're going to get. If you're not in this country with permission, you violate the laws and you go to jail and immigration finds you there, they will put a detainer on you and you will sit in jail until this case is over with. And then you will be shipped off to immigration, where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. If you do not want that to happen, do not violate the conditions I put on your bond now. If you violate these conditions, I will issue a warrant, put you in jail, and that's it. Do you understand?
Yes, sir.
Okay. Like I said, no alcohol, no illegal drugs. You will be randomly tested. If you fail to go test, likewise, a warrant will be issued for your arrest. A protective order was issued in this case on December 6th. I suggest that you get to know it. If you violate the protective order, the state can, possibly will file a violation of protective order against you, and it's one of the worst cases that you can pick up in misdemeanor court. Do we know whether she wants to have contact with him, guys?
Your Honor, no, RIP was attempted, but she was unable to speak at the time that we called. So we'll call again when we can.
I don't know whether she wants to have contact with you. So until I know that, I'm ordering you not to have contact with this person. I don't care what your excuse is. Excuses mean absolutely nothing to me. What matter are choices. You can either make a wise choice or you can make the wrong choice. You know what the expectation is here, and if you make the wrong choice, there's only one place we have for you. Do you understand? No alcohol, no illegal drugs, no weapons. Don't have any contact with this person, and don't violate the protective order. Do you understand?
Yes, sir.
All right, we're going to reset your case to give you time to hire a lawyer. So I'm going to first have you go to Victoria, sign a reset. I'll have you meet with Felicia for your bond conditions, and after that, you're free to go.
Today's docket was quieter than most, but in its quiet, it revealed something that the loudest dockets sometimes obscure: the justice system at its most human. We watched a young man walking from humble, no bus, no car, no money, arrive at that courthouse on foot, because he understood that showing up was the only thing standing between him and losing everything. We watched a homeless man who came to court not because he had to, but because somewhere inside him he still believed good things could happen when he did. And we watched a judge stop everything, slow down the entire machinery of a packed docket, to ask a social worker one simple question: what can we do to get this man off the street? We watched a CPA who makes $8,000 a month sit at that podium and hear the same warning as the man who makes $200 a week cutting grass. Because in that courtroom, the law does not ask what you earn. It asks only whether you will follow it. We watched a judge tell a young black man that a theft conviction is one of the worst things life can brand you with. Not because of what it costs in court, but because of what it costs in every room you will ever try to walk into for the rest of your life. And we watched over and over that same judge offer the same thing to person after person. Not mercy as weakness, not leniency as indulgence, but something rarer and harder to name. A genuine belief that the person standing at that podium, whatever they had done, whatever they were struggling with, was still worth the effort of trying. The 8th Amendment forbids cruelty. The 14th Amendment promises dignity. But no amendment has ever been able to mandate what today's docket had in abundance: the willingness of one institution on one ordinary morning to look at the people society had given up on and say, "Not yet. Come back. Good things happen when you do."